Good morning. I'm Tony Lopresti, County Counsel for the County of Santa Clara, and I'm honored to be joined here today by Attorney General Rob Bonta, Supervisors Sylvia Arenas, Betty Jung, Otto Lee, and Susan Ellenberg, County Executive James Williams, Chief Operating Officer Greta Hansen, and an extraordinary team of attorneys that I'll introduce a bit later. I also want to recognize Representative Zoe Lofgren's District Director, Edwin Sevilla, who is here in attendance. We're announcing today that the county has joined forces with Attorney General Bonta to file a federal lawsuit against ICE, the Department of Homeland Security, and the owner of 7240 Holsclaw Road, alleging that their sudden and secret development of an ICE facility at the property is reckless and unlawful. Our suit sends a simple message. In this county and in this state, the law doesn't yield to the Trump administration's crusade against the immigrant community.
That's right. Yep.
We are ready, we are willing, and we are able to hold the federal government accountable in the courts. I'm going to start off by providing an overview of the case and our claims. I'm then going to hand the mic to Attorney General Bonta. I'll provide a very quick summary of my remarks in Spanish, and then we'll open up for questions. Let me start by setting the scene a bit and talking about how we got here today. The Holsclaw property is a 25-acre parcel near Gilroy here in South Santa Clara County. It sits along a narrow winding road near Llagas Creek and is zoned for exclusive agricultural use. A few months ago, we began hearing rumors that an ICE facility would be constructed at the site. And we learned that the property owner had entered into a 20-year lease with the federal government for over $26 million. Over the last 6 weeks, community members began reporting demolition at the site. And the San Jose Spotlight published blueprints confirming that the site is being developed as an ICE facility with holding rooms capable of detaining up to 150 individuals. Now, we can't tell from the blueprints exactly how ICE might classify this facility. But what we do know is alarming. We have reason to believe it's a facility designed to temporarily hold detained individuals before shipping them off to larger detention facilities. It's the type of facility that is the subject of lawsuits throughout the nation for warehousing people in inhumane conditions. It's the type of facility that has signaled an increase in enforcement throughout the region. The response from community, partner jurisdictions, and elected leaders has been swift and certain. Outrage that the federal government would construct a facility with such a massive impact with no stakeholder input whatsoever. Our Board of Supervisors, as it has done so many times during each of the Trump administrations, tasked our office with taking appropriate legal action to hold the federal government accountable. And without hesitation, Attorney General Bonta's office reached out to coordinate and help lead that action. Our office's attorneys have been working at breakneck speed to put together a lawsuit demonstrating the myriad ways this development violates federal and state law. We allege violations of the National Environmental Policy Act, the Intergovernmental Cooperation Act, the Immigration and Nationality Act, the Administrative Procedure Act, and California's Williamson Act. But you don't need to be a lawyer to understand this lawsuit. There is a quicker, simpler summary. This is the wrong place and the wrong process for this facility. Let me start by explaining why it's the wrong place. First, we've learned that there's a history of hazardous materials stemming from long-standing research and development activities at the site. We've uncovered 3 decades of documented leaks and spills of chemical compounds. That means that there is, as we speak, active construction, disturbing a potentially contaminated site, putting construction workers and employees and potentially detained individuals at severe risk. Second, the infrastructure for this property is not set up to serve an ICE facility with detention space. Take wastewater as an example. Even though the blueprints, shockingly, appear to call for a hookup to a sewer system, the closest sewer system is almost a mile away. And the septic system at the property was designed for a modest daytime use, not for a 24/7 use with 60 employees and approximately 150 detainees. Moving forward with the existing system could send wastewater to the soil surface, putting pathogens in contact with employees and detained persons, and sending wastewater into Llagas Creek. And any septic system expansion would necessarily be built in the floodplain, compounding the risk of a catastrophic failure. Third, construction and operation will impact the surrounding environment, generating potentially devastating impacts for endangered species. That includes a subspecies of steelhead in Llagas Creek, which runs directly alongside the property. And finally, the property is located within one of the last remaining areas of the county that is preserved and protected for agricultural use. In fact, the property is under a legally enforceable contract restricting the land to agricultural uses in exchange for a huge cut in property taxes. Those contracts have been in effect for 60 years. The current landowner is subject to that contract, and so too is the federal government as the lessee. So the Holsclaw property is the wrong place for this facility. Let me tell you why it's the wrong process. Under the National Environmental Policy Act, federal agencies must disclose and analyze potential environmental impacts, and they must do that before they take action. Here, they completely ignored their legal obligations. That means that all those impacts I just mentioned, hazardous materials and endangered species, infrastructure, agricultural preservation, they were undisclosed and they were unexamined. And under the Intergovernmental Cooperation Act, the federal government was required to solicit and consider the viewpoints of state and local governments. Instead, the federal government hid the facility's intended purpose and made no attempt whatsoever to solicit our views. The facts in our lawsuit show that defendants have taken reckless action. Rather than following the law and their own guidance on cooperating with local and state authorities, they chose instead to ram this project forward in secrecy, completely ignoring the local impacts. That ends with this lawsuit. We will be seeking injunctive relief from the court that puts a stop to the project and requires compliance with the law. The truth is, we shouldn't have to wait for the court to act. With the facts out in the open and full vision into the impacts, the federal government has everything it needs to know to just walk away from this project. If the defendants persist, we're confident the court will restore the rule of law. I want to express gratitude to our Board of Supervisors for their courageous leadership through a time of intense adversity. There are so many elected officials in this nation that have been choosing to pander to the Trump administration. Our board has done the opposite. It has stood firm in its support of the county's equity-driven principles. Before I hand the mic to Attorney General Bonta, I want to acknowledge an exemplary team of attorneys that has been working day and night on this case for many weeks. For the county, Rajiv Narayan, Layli Arzi, Sonia Wills, Meredith Johnson, Elizabeth Pianka, and Kavitha Narayan, as well as our investigator, Ricardo Murillo, our outside counsel at Shute Mahali Weinberger, Bill White, Matt Zinn, and Caleb Hirsch, and our partner at Stanford University, Professor Michelle Wild-Anderson. Speaking of courageous leaders and excellent attorneys, I'm going to turn it over now to our partner in justice, Attorney General Rob Bonta. Our county and our communities could not be more fortunate to have Mr. Bonta as an ally and the top attorney in the state. He has been a leading force in the litigation against the Trump administration, filing dozens of lawsuits in coordination with other blue state attorneys general. And while so many of those cases deal with big nationwide policies, his immediate willingness to champion this local fight, to focus his team of talented and dedicated attorneys on this fight, speaks volumes about his attentiveness to the community and the impacts that folks are feeling on the ground. It's precisely the kind of leadership that we so sorely need. Thank you.
Hey everyone, Rob Bonta, California Attorney General, and let me just start by expressing my appreciation for County Councilor Presti. Thank you for your kind words. Thank you for your courageous leadership. Thank you for your partnership on this important case. I have nothing but admiration and respect for you and your team, and we are proud to stand with you in this important fight and this important litigation. I want to also say thank you to my team at California DOJ. I'll be mentioning a number of them by name towards the end of my remarks. I specifically want to say thank you to our environmental justice and protection section for their incredible work on this case and helping us get to where we are today. Government is at its best when all levels work together to serve and to protect the people. And that's what you're seeing today. It's what constituents, Californians deserve. They deserve state and local government teaming up on behalf of this community, and that is on full display right now. Unfortunately, not only is the federal government not working with us, they're actively working against us, against the law, and against the best interests of Santa Clara County. Since returning to office, President Trump and his administration have led a mass detention and deportation campaign that has led to cruel, inhumane, and unacceptable conditions at immigration holding and detention facilities across California. Conditions my team has made public in multiple reports, including one that we just put out last month. And the conditions of detention are absolutely horrific and unacceptable. We are seeing detainees not have access to clean, potable water, not have access to appetizing, nourishing meals, although that's required in their contract, not getting health screenings and health care appointments and follow-up appointments, not having adequate clothing or bedding at night to stay warm in the cold temperatures. And the list goes on. Basic human needs not being provided to the detainees, and most of the detainees shouldn't even be in detention. They are, in the past, have been eligible for bond to be in the community. Most have families, have jobs, have strong roots in the community, have no criminal record, can be and should be in the community, not in these detention centers with subhuman conditions. And instead of working to improve these disastrous conditions, instead of making earnest efforts to treat detained individuals with the humanity and dignity that they deserve, the administration is trying to jam through a new facility on a community that does not want it. Bulldozing over laws, shrouding their plans in secrecy, and ignoring calls from the community to stop. The administration may claim this would be an ICE office with only short-term detention capacity. But we've seen what that really means in other instances. Across the country, ICE has been misusing short-term holding facilities as de facto long-term detention sites where people face overcrowding, prolonged multiple-day detention, and other inhumane conditions without required safeguards, services, and oversight required for extended confinement. The administration is treating immigration enforcement like a business, turning it into Amazon Prime, but with human beings. That's a quote, as former acting ICE Director Todd Lyons put it. It's despicable And as County Councilor Presti laid out in great specificity, it's illegal. The administration is ignoring the fact that the property near Gilroy is zoned exclusively for agricultural use and subject to a contract to preserve this use, ignoring the environmental and health concerns, ignoring the negative impacts this facility could have on sewer infrastructure, drinking water, local roads, and the surrounding ecosystem, and ignoring their obligation to consult with and consider the views of the county and the state. The Trump administration is ignoring the law and the wishes of the people of this state, unfortunately, yet again. We've seen this movie before, which is why we're taking them to court yet again. Before I close, I want to say a few remarks in Spanish. El presidente Trump y su administración han llevado a cabo una campaña masiva de detenciones y deportaciones. Esto ha creado condiciones inhumanas en los centros donde mantienen detenidos a inmigrantes a corto y largo plazo. Ahora quieren abrir ilegalmente un nuevo centro en una comunidad que no lo quiere. La administración de Trump está ignorando nuevamente la ley y lo que quiere la gente de este estado. Por eso, una vez más, los estamos demandando. Thank you. So for those keeping track, this marks the 71st lawsuit we've had to file against the Trump administration. And it's about 71 lawsuits in about as many weeks, so about one lawsuit a week. And I wish that this was not the case, because that would mean necessarily that the president and his administration are following the law, are upholding the Constitution, and treating people of this country with dignity and respect. I've said it before and I'll say it again. When the president breaks the law and hurts our people and our state, we will take action. And we are yet again today. My job is to protect California and all who call the Golden State home, no matter where they're from, how they look, what language they speak, or where they live. And finally, before I turn it back to County Councilor Presti, I want to again thank the individuals at California DOJ who put their time and energy into this case, who helped us get to where we are today. Stacy Lau, Ashley Werner, Jessica Durney, Erin Ganal, Abby Blodgett, and Deborah Smith. I'm proud to serve alongside every one of these incredible public servants. With that, I'll hand it back to you, County Councilor Presti.
I'll share a few words in Spanish as well, and then we'll open it up for questions. Thank you, Attorney General Bonta, for your very powerful remarks. Hoy anunciamos que el condado se ha unido con el fiscal general de California, Rob Bonta, para presentar una demanda federal en el Tribunal de Distrito Federal contra ICE, el Departamento de Seguridad Nacional y el propietario de 7240 Jos Clara cerca de Gilroy, alegando que su desarrollo repentino y secreto de una instalación de ICE en la propiedad es imprudente e ilegal. Nuestra demanda envía un mensaje simple. En este condado y en este estado, la ley no cede ante la cruzada de la administración Trump contra la comunidad inmigrante. Estamos listos, dispuestos y capacitados para responsabilizar a ICE y al gobierno federal en los tribunales. Nuestra demanda se puede resumir fácilmente. Este es el lugar equivocado y el proceso equivocado para esta instalación. El gobierno federal no ha revelado ni evaluado impactos graves, como impactos de la infraestructura de aguas residuales, impactos a especies en peligro de extinción y la contaminación por materiales peligrosos. y el gobierno federal no ha logrado coordinarse ni cooperar con los gobiernos estatal y local para comprender nuestro punto de vista, tal como lo exige la ley federal. Estamos pidiendo al tribunal que detenga este proyecto y exija el cumplimiento de la ley. La verdad es que no deberíamos tener que esperar a que un tribunal decida este caso. Estamos bastante seguros de que con los hechos expuestos y una visión completa de los impactos, será evidente para el gobierno federal que debería retirarse de este proyecto. Sin embargo, si los demandados persisten, confiamos en que el tribunal fallará a nuestro favor. Gracias. We'll take any questions.
This question is for Attorney General London. Ms. London, could you tell me, please, how much of this lawsuit is, how much of this is a strategy to tie this matter up in court until the next administration? And then, if it turns out that the government is going to run the facility itself, how do you overcome the Constitution supremacy clause that gives the federal government the right to
Thank you. For those who didn't hear the question was how much of this lawsuit is a strategy to delay the building of the ICE detention center until the next administration, and how do we overcome the supremacy clause, which, as this is part of the question, not my interpretation of the supremacy clause, which allows the federal government to do whatever they want. So let me push back on the question a little bit. On the second part, the supremacy clause does not allow the federal government to do whatever it wants. There is a whole amendment in the U.S. Constitution, the 10th Amendment, that provides for states' rights, state sovereignty. That constitutional amendment has been interpreted by the courts. There's a whole robust set of case law that provides robust state rights. And we have exercised and advanced our and reaffirmed our states' rights in our lawsuits, all 70 plus of them. We've gone to court time and time again. We've prevailed. We've stopped and blocked the Trump administration from breaking the law, from violating the Constitution. We've protected $200 billion of funding that is ours in California, that Trump tried to wrongfully withhold, funding for healthcare and education and housing and food. We protected constitutional rights like birthright citizenship and voting rights. We have pushed the unlawfully deployed and federalized National Guard out of our state because it was unlawful for them to be here. Thank you. We struck down unlawful tariffs that were raising the costs for Californians and Americans twice. We defended Prop 50 in court as well. So we are asserting our existing rights. The Supremacy Clause does exist. The Intergovernmental Immunities Clause does exist. But that does not allow the federal government to do what it wants, whenever it wants, as our cases have shown time and time again. In our cases where we sue the Trump administration to stop it from doing what it wants, when it wants, we win. We're winning 80% of the time. So I'll just push back on the second part of your question. The Supremacy Clause does not allow the federal government to do what you have suggested. Our cases, many of them, so the 70 plus cases, are proof positive of that point. How much of our strategy is a strategy to delay the building of the facility until the next administration? None of it. That's not our strategy. Our strategy is do lawful things. Don't do unlawful things. As set out by County Counsel Lopresti, the place and the process is unlawful. And we've laid out in enormous detail our multiple arguments. These are laws that the federal government has to follow. The National Environmental Policy Act, the Intergovernmental Cooperation Act, the Immigration and Nationality Act, the Administrative Procedures Act. Those are their laws. Those are federal laws that they need to follow. And they're not. And so we have a very simple proposition here. Follow the law. If you follow the law, we can't sue you. If you break the law, we'll see you in court. This is us saying we'll see you in court. And as County Counsel Lopresti rightfully pointed out, they can and they should back down. Having seen our case, seen our arguments, seen the facts, seen the law, they are in the wrong. They are acting illegally. Will they? I have my doubts. That's what we have courts for and court orders for. And that's what we are seeking through this litigation, a court order to end their unlawful conduct. That's it. That's the whole case.
Your knowledge, has any construction of you guys' facility, proposed ice facility been started on the property, and have they applied for any county permits at all?
I'll answer part of that question and I'll turn it over to my colleague here. I believe that they've started the project and it was started in May. So it is underway, and I'll let County Councilor Presti provide additional detail.
So again, they have not been in communication with us, so we don't know the details beyond what we are able to see from the public right-of-way. What is clear is that there are demolition activities occurring. It appears that there's construction activity occurring. No, they have not applied for any kind of county permit or reached out during this process in any way, shape, or form to explain what they're up to. Oh, sorry. Any other questions?
Do you have an anticipated timeline as to when either you or the state can get a hearing in this case? What's the timeline?
Do you want me to take that? The question is, do we have any anticipated timeline for when we might get a hearing in this case? So we are looking at a potential of filing a motion for preliminary injunction. If and when we file that motion, we will have a hearing timeline set at that period. I think what's clear is that we need to move expeditiously. That's why we've moved as quickly as we have to get this lawsuit on file. And we will certainly be looking for the court to take action quite soon. It's not definitive when that hearing will take place yet, but I don't think it's too far off. Anything to add?
Today we're filing the complaint. We don't have an accompanying temporary restraining order application or a motion for preliminary injunction. And in the cases that we've brought, the 71 cases that we've brought, sometimes we've sought a TRO or a preliminary injunction. Sometimes we've just moved rapidly to a summary judgment hearing and won on summary judgment and moved towards final judgment. But we know we have to move expeditiously. Speed is important. We have the urgency. What that will look like in terms of what form of motion or hearing still to be decided, but we're going to be moving expeditiously to get a court to rule on this unlawful conduct by the federal government. Yeah, we can. So the question is, we know that the project is, the construction is ongoing, and when can we expect some sort of action, and what would that action be to stop that construction, if that's even possible? That's the whole point of the litigation, of the lawsuit. We filed the complaint today. We put our marker down. We set forth our arguments, the facts, as we understand them, and then we'll be seeking relief, which is a court order blocking the ongoing construction. And in litigation, you can sometimes get preliminary or temporary orders saying, through the pendency of the litigation, as the case continues, you are ordered to stop building. And then we can move towards a final judgment. The federal government will also have appellate rights. They can appeal certain orders and certainly final judgments to the appellate court, maybe even eventually to the U.S. Supreme Court. But we have secured orders, and we will seek one here, blocking the construction during the pendency of the case. And usually you need to show some likelihood of success on the merits. We think we've shown that. Also some potential for irreparable harm. We believe we can show that as well. That would be if we seek an emergency application. But we might just move towards summary judgment and get an order there. But during the pendency of the litigation, we expect to get an order blocking the ongoing construction. Any other questions?
I have a question for Mr. Presti. So this is a smaller, this is like a temporary detention facility. Their county zoning prohibits detention facilities not land, if I understand correctly, in that area. Does this smaller facility is it also like banned by zoning ordinances?
The question is whether this smaller type of detention facility, what we're anticipating as a temporary holding facility is allowed or is not allowed under our zoning code. Our zoning laws do not allow detention facilities of any kind. The way our zoning code is structured is it actually states what is permitted. And nowhere in our zoning code does it state that a facility that is designed to detain human beings is allowed. Certainly not on this particular parcel. Yeah.
If you've had no communication with the federal government, how do you have the proof of what is actually happening on the property?
The question is, if we haven't received communication, during the construction of this facility, how do we have proof of what's occurring? What is alleged in our complaint is based on a whole host of different sources. So we're focused on what we're able to see from the public right-of-way, what has come out in the press, including an 111-page set of blueprints, and comments that the federal government has made in the press effectively confirming that they are working towards this particular type of project. So, I think part of the problem here is that they are trying to move forward with this project with as little transparency as possible and hoping that nobody notices, nobody catches on to the details, right? So part of what our lawsuit will do is it will force that transparency to occur. And Attorney General Bonta spoke about, preliminary injunction or a TRO or whatever stay we might be able to achieve. But there's also discovery in a lawsuit. And to the extent that we aren't able to obtain the information that we need to really understand what's going on from public sources and from our own investigation, we'll be able to demand it through the discovery process. And, I think we have enough information to know that this is absolutely the wrong place and the wrong process. And the fact that we're learning about it in drips and drabs from the press and from various sources, I think just drives home the point about how wrong the process has been. Anything else?
Great.
We know the fear that is in the community right now. We've seen what's been going on in LA. Probably we haven't had those rates in the Bay Area yet. With a processing facility or detention facility, probably processing facility in our area, do you guys believe that probably meant there will be more ICE presence in the area and also the rates probably similar to what we've seen in South California?
I'll take a first crack at that and then hand it over to Attorney General Bonta. What I will say is that the community reacted to this immediately with concern. I'm sorry, I should say the question back. Is there a real concern that this kind of development foreshadows that there will be increased enforcement in the region? I think the answer is absolutely yes, and I think the community's reaction is indicative of that. I think we have seen a trend that when the infrastructure for this kind of enforcement is built, it signals that there is going to be an immediate ramping up of detentions and all kinds of different ICE activity. So a big part of what the community and the region's leaders are reacting to, not just the construction of the facility, but the fact that we could see more ICE presence, more disruption in our economy, more disruption in our education system, more disruption in our society being able to operate with a common basic sense of security and safety. And being able to push back on this facility, I think, is part and parcel of being able to demonstrate to the immigrant community and to our community more broadly that we're there standing in solidarity with them.
Thank you. And let me just say that my mother is an immigrant from the Philippines. I was born in the Philippines, brought here when I was an infant because my parents wanted a better life for me. They wanted opportunity, a better life. They wanted democracy and freedom, due process, the rule of law, all of which were being taken away by a dictator rising to power in the Philippines. And so to the immigrant community, I say, we see you, we value you, we will fight for you. We will fight for your dignity, your humanity, your rights. We will fight to make sure that the federal government follows the law. And that's what this is about. The building of a ICE facility here in the region definitely signals increased enforcement. And so we can't be naive about that. And we're not. And we have a very simple standard here. We're going to hold the government's feet to the fire on following the law. They have violated it in multiple ways, so they cannot continue with their proposed project based on the law. But there, of course, as you mentioned, there are there's a broader context here. And unfortunately, the federal government has been cruel, inhumane, unlawful, xenophobic, racist, discriminatory, and in many other words that apply in their treatment of the immigrant community. And that is not who we are or who we will be here in California.
The question is, given all the evidence that we see right now, what is the probability as we foresee of success? Well, I think we put forward this lawsuit because it's very clear that there have been violations of the law. And if there's one institution that we have to count on, it's the courts right now. And we believe 100% that the courts are going to apply the law and that will prevail in the courts. We couldn't be more confident in the allegations that we're putting forward. We're quite sure that the federal government will try to hide behind the supremacy clause and intergovernmental immunity on every single one of our claims. We don't think they can. And so, this lawsuit will play out over time. As I said during my remarks, it doesn't need to. The federal government can recognize on its own, sua sponte, as we say as attorneys, right? Recognize that this is not the right place, that they messed up the process, and they can walk away from the lease they've signed, and they can follow the law. And so, either they do that on their own, or we make them do it in the courts. The question is whether we are considering filing any lawsuits in state court regarding this facility. We have sought consent to do an inspection on the property. And if we do not receive consent from the owners of the property, we will be going to state court to seek a civil inspection warrant that will allow us to get onto the property. But the lawsuit in principle is going to be is filed in federal court, not in state court. That's primarily where we'll be litigating this case.
We know the World Cup is starting tomorrow. We have 14 matches combining LA and the Bay Area. We've seen the eyes of DHS. They've been posting on the social media that they're going to be nearby the stadiums. They're going to be targeting those people, selling counterfeit products and all of that. But we also know a lot of people, the immigrant people, they're street vendors and they might be afraid. How are you guys prepared for this?
Yeah, thank you. Let me just first say, as a father of a professional soccer player and a huge soccer fan, I'm very excited about the World Cup generally. That is muted by the federal government's approach to their ICE enforcement during the World Cup, which is very disturbing and something that we are monitoring closely. The federal government does have the ability to enforce federal law, including immigration law, if they do it lawfully, if they do it in the right way, with the right procedures. They have not done that time and time again. They have violated the rights of immigrants, including those who are lawfully present here. They've even violated the rights of U.S. citizens in their abusive conduct. There's a whole court case out of Southern California in the federal court that talks about how they racially profiled and otherwise profiled in their immigration enforcement. They use race as a factor, and the perceived language spoken and the perceived job of individuals and their location as reasons to enforce immigration law, and that was improper. So unfortunately, we expect them to be engaged in some of the same unlawful conduct. They have a very hard time complying with the law. And so our job will be to hold them accountable if, and unfortunately, likely when they break the law, to make sure that the rights of Californians are being protected and honored by an abusive federal government, unfortunately, that's enforcing immigration law. So we're watching closely, we're monitoring, we're very aware of the upcoming matches at Levi Stadium and SoFi Stadium. We want people to enjoy this incredible global celebration of the beautiful game, and to be able to do that safely, securely, without being discriminated against, without being abused by their government that's hosting the World Cup. And so we'll do everything in our power to make sure that that's the case.
Thank you so much. Really appreciate everybody coming out to cover this matter.